everybody to the Laguna Woods Democratic Club program for November. I am Susan Deering, the Vice President of the club. Linda Nearing, the President, sends her best wishes to everybody. Today we have the great fortune to have as our speaker Michelle Bratcher Goodwin, who is who is the Chancellor's Professor at UCI Law School, and she will be speaking to us today on the implications of the appointment of Amy Coney Barrett to the Supreme Court and the settled and future rights at risk. Michelle Bratcher Goodwin has been a speaker with the Laguna Woods Democratic Club before, and everyone welcomes her back enthusiastically. Thank you so much, Michelle, and welcome to the program.
Well, thank you very much. It's a pleasure to be with you and the audience today. You've asked me at a critical juncture in our American legal history to join you as we think about the future of the Supreme Court, and particularly with the confirmation process of Judge Amy Coney Barrett, who currently serves as a judge on the Seventh Circuit and has been on the Seventh Circuit, not for a very long period of time, but just simply during this Trump administration with a confirmation appointment that took place in 2017. Now, as a backdrop for this conversation, I think it's important to situate what it is that we're talking about. And that is to say that what we've seen very recently is the passing of Justice Ruth Bader Ginsburg. And I think it's very important that we begin there and we understand the history of Justice Ruth Bader Ginsburg on the court and the legacy of how she got there, because I think that says a lot about our country and about how we understood these processes to be. Justice Ruth Bader Ginsburg had her first appointment to the federal bench by President Jimmy Carter. President Jimmy Carter was really a forerunner for his time, and that is to say that he nominated and there were appointed a number of women for the first time to many of the federal benches, including the federal circuits of appeal. During his time in office, he actually had confirmed to the federal appellate judiciary, which is that pipeline right under the Supreme Court, 6 women. And these were in circuits that for more than 100 years had never had one woman on, and he put 6 on the bench. And these were not just white women, these were also women of color, and also at the lower federal benches too. Men of color, women of color, white women. That was his legacy. And very interestingly, for the DC Circuit Court of Appeals, where Judge Ruth Bader Ginsburg got her start, she was actually not the first woman that he nominated to that court. That legacy, that commitment to the diversification of our courts, to courts representing the populations that they serve, was something that we saw in the legacy of President Jimmy Carter. What we haven't seen very recently over the last 4 years through the nomination and confirmation process under President Donald Trump has been a commitment to that level of diversification. At the federal courts of appeals level, as of July, of the 53 judges at the appellate court federal level, there were no African Americans, only 1 Latino. Overwhelmingly, these have been white males that President Trump has put forward and that have been confirmed by our Senate in 2020. Very different from the work that Jimmy Carter was doing 40 years ago. I think that's an important start. The second thing that's an important start is to think about who actually serves on our federal bench, our courts generally, and not just the Supreme Court. When you think about the legacy that Jimmy Carter left behind in this way, and this is purely nonpartisan, this is just thinking about what a president does and who a president selects to serve on the bench. President Carter selected judges who came from all walks of life, that is, individuals who could relate to the American public that they serve. For Ruth Bader Ginsburg, it's important to understand that she was not coming from a very large law firm. She was not coming from a law firm of any kind. She was also not coming from a large corporation. Instead, she was coming from the American Civil Liberties Union. She was coming with the experience of a professor, but a person who was working for the Women's Rights Project at the ACLU. That's very different than what we've seen in recent years with appointments to the federal bench and certainly the Supreme Court. We're not seeing individuals who've actually represented individuals who've been plaintiffs, individuals who have been defense attorneys working, in fact, for some of the for individuals who are the most indigent in society. We've not seen appointees who are working in civil society on behalf of the environment, on behalf of women's rights issues, on behalf of children's rights issues, on behalf of the elderly, on behalf of making sure that people have clean air and clean water to drink. And that is actually saying a lot about where are the capacities of the people who are coming onto the court that we would want to see. The final point that I'll make before talking then about what this all means specifically for us in terms of the kinds of issues that a court sees, it's important to reference that we don't know exactly how Judge Barrett might rule on issues if she comes onto the Supreme Court, but there's some indications based on her record, what she has written, both as a professor and also as a jurist, and the kinds of things that she has actually said. Those are the things that we can actually point to. And so as I move to that, it's important to know that before the court, what's at stake are many different matters. Many people have looked at these issues as being matters just as related to reproductive health care and rights that one should be concerned about. And that's actually not the case at all. There's far more, I mean, that's serious in and of itself, but there's far more than that for which we should all be mindful about. Many people will think back in 2016 when President Barack Obama wanted to, and in fact had nominated Merrick Garland to the court. And Merrick Garland, though there were 8 months before the election, could not get a hearing before the Senate. Many of the same senior people in the Senate is still being in place who've been pushing forward the Amy Coney Barrett hearing and nomination process, who've taken a completely different stance, some of whom 4 years ago, mark my words, you can repeat these words back to me, that there should be no nomination and no confirmation process right before an election, that the people should actually decide in an election. We're right now in the middle of COVID, and there have already been somewhere between 20 and 30 million ballots that have already been cast, and this process is moving forward. I just take that slight digression in the talk to just simply mention that because many people are concerned about the process and what this process represents in terms of the legitimacy of the court and whether the legitimacy of the court happens to be at stake. That's something that perhaps we'll get to in the Q&A portion of this conversation. Now to Judge Amy Coney Barrett and what's at stake. Well, I think we ought to frame this as more of what's at stake generally with our Supreme Court, not just with Judge Amy Coney Barrett. As I mentioned, we don't necessarily know how a judge will rule on any particular issue until they're actually on the Supreme Court. But we do have some information that guides us with regard to her positions on issues as she has been a lower court judge over the last couple of years, and then also in her writings as well. So there are going to be some areas where there are going to be fewer surprises. For example, at her White House announcement by President Donald Trump, Judge Coney Barrett emphasized that she sees herself in the likeness of Justice Scalia. While Justice Scalia was on the court, he fashioned himself as being the most conservative justice on the Supreme Court. He described himself as a textualist and an originalist. And for the viewing audience, I'll just say briefly that people who describe themselves as textualist and originalist believe that the Constitution should be interpreted as it was originally drafted, and that judges are responsible for looking to the text of documents, the original text of documents. So if you see the Constitution as a text, the original text of what the Constitution was, that's the idea. Where people have trouble with that is that they believe that the founders, or some people believe that the founders never intended for the Constitution to just be interpreted as people understood it in the 1700s, but that the framers of the Constitution had an idea of an evolving Constitution. We can see that in the Ninth Amendment itself, where there's room left in the Constitution for further interpretation of problems that must be resolved that perhaps could not be predicted in the 1700s. But of course, for those who want to take seriously what that means, whether one is a textualist or not, if you think about where the United States was in the 1700s, to have a Supreme Court committed to an understanding of law based on the 1700s, well, that was a time where the United States was deeply wedded and embedded in the institutions of slavery. It is a time in which the United States was generating significant wealth off of slavery, not just, but it's what bankrolled Wall Street as well. There was more capital that was generated from slavery than in our railroads and our other industries that were emerging at the time. It was a time in which women were considered to be the property of their husbands and their fathers and so forth, and could not vote, in fact would not actually have a right to vote until the 1900s. And for African Americans, that really wouldn't be fully secured until 1965 with the Voting Rights Act. So for those who are a bit concerned about justices who fashion themselves as originalists and textualists, that is what they are concerned about, that viewing American equality and democracy during that lens is one that does not reflect our evolved notions and understandings of equality, liberty, and freedom in the United States. But Judge Amy Coney Barrett has said that that is how she sees herself. She fashions herself within the context of Scalia. And so one thing that you could do is to look at how Justice Scalia viewed any number of issues to see how then she might come out, given that she says that she would be closest to his leanings. And she was a clerk of Justice Scalia. On the topic of abortion and reproductive rights, let's talk about that. There's quite a difference between Justice Ruth Bader Ginsburg and where Judge Amy Coney Barrett sees herself. She has signed on to documents, including advertisements in newspapers that call for an outright ban of abortion, and with no room for in vitro fertilization for families that would like to build their families through assisted reproduction, and that also see no exceptions. Typically, we see exceptions even in the most conservative of states, although that is changing, with regard to rape and incest. And so Judge Amy Coney Barrett, it appears from both the stances that she's taken in terms of her personal views and also professional views, it would seem that she's a hardliner in that regard. But the concern here shouldn't just be abortion rights. It should also be other aspects of reproductive health care rights and justice, including contraception. It was in the Burwell v. Hobby Lobby case just a few years ago, while Justice Scalia was still on the court, that Justice Alito penned an opinion for the Supreme Court that equated contraception such as IUDs with abortifacients. An IUD is a form of contraception. Plan B is a form of contraception. These are not abortifacients, but in this case, challenging the Affordable Care Act, the Supreme Court really didn't do its due diligence and really didn't craft a specific case that actual facts that exist in the real world of health and science, but instead sided with companies that wanted to foreclose from women the opportunity to receive contraception under their healthcare plans, such as IUDs and whatnot. And these companies claim that they should be able to foreclose women on their women employees from these kinds of contraception in their insurance plans based on their religious identity. So it was the first time in Burwell v. Hobby Lobby that the Supreme Court said that yes, privately held corporations can have religious views, and those religious views can dictate then what it is that they choose to do. That was unheard of. Now, to be clear, the Supreme Court said, well, these are closely held corporations. And for the average American reading that, closely held, they might think about these as mom and pop organizations, but they are not. the overwhelming majority of US companies are actually closely held corporations. Hobby Lobby employs tens of thousands of employees. So these are not mom and pop stores on the corner, but rather can be big corporations. It's important to note that in that case, the Supreme Court also made clear that it was applying its ruling only in the context of contraception, and that this didn't actually apply to other areas where there could be corporations that want to claim a religious identity in order to infringe upon constitutional rights. So that's one area. The Affordable Care Act is another area in which people have concerns. Justice Scalia was a person that when the case, a justice that when the case came before the Supreme Court, voted against upholding the Affordable Care Act. The Affordable Care Act was actually saved by Justice John Roberts siding with the liberals on the court. What many fear is that with Coney Barrett on the court, what this could mean is that they're going to be 6-3 majorities, or even if they're 5-4 with Justice Roberts siding with the liberals on the court, that the conservatives will actually have the votes to defeat acts such as the Affordable Care Act. Hearing, which will be taking place next month, the issue will be before the court. And so that's something for people to watch. But there are also other issues too that are deeply concerning for individuals, and those also relate to issues such as voting rights. This has been a Supreme Court that has recently been hostile towards voting rights, even within the last 48 hours, with the Supreme Court's majority engaging in what some would call the shadow docket, meaning that the Supreme Court issues a ruling, but the majority actually doesn't articulate anything about their ruling. In Alabama, where organizations advocated for people to be able to do drive up, drop off ballots, the Supreme Court struck down that possibility. The only writing that we have from that happens to be with the dissent being penned by Justice Sotomayor, a 3-person dissent, but we have no idea why the majority of conservatives on the court sided in this way. It actually calls to mind a case from this summer, which was our last dissent, seemingly, from Justice Ruth Bader Ginsburg in a case that involved voting rights in Wisconsin during COVID. And of course, that's why we had this Alabama case too. There, in that case, you had Republicans challenging Democrats who were challenging the governor. The governor had wanted, through the authority of his office, to extend the counting for mail-in ballots and to also extend primary voting. And this was challenged by the Republican Party in the state of Wisconsin. And the challenge went up to the Wisconsin Supreme Court and also went before the United States Supreme Court, where Justice Ruth Bader Ginsburg issued a dissent because the majority would decide, and did decide, with shutting off the counting of the ballots and imposing the same date of voting that Tuesday, not extending it as the governor would have wished. What Justice Ginsburg said in her dissenting opinion was that there was a terrible ultimatum that the people of Wisconsin were subjected to, and that is risk their health in order to exercise their constitutional right to vote. It's worth noting that Justice Ginsburg wrote this in the peak, where we are still in the peak of COVID, but it's worth noting that in Wisconsin at the time, and I'm sure she was aware of this, one would think so, as learned a person as she was, and how she dotted every I and crossed every T, was that the peak of deaths in Wisconsin at the time were among Black people in that state. At the time, 40% of the deaths that were associated with COVID happened to be Black people, though they made up only 6% of the state's population. So the concern that she raised in her dissent about what people were being subjected to was quite real, particularly given the fact that one of the trends that we have seen, which certainly doesn't help our democracy and voting at all, has been to reduce the polling sites that take ballots. In Wisconsin, this had in fact been the case. In one of the counties alone, the polling places had been reduced to only one for an entire county that had a mixed race population. So voting rights happens to be a concern. There are those that say that they don't know exactly how a justice, Amy Coney Barrett, would adjudicate on these issues. But what has been clear is that in her prior writings, it would suggest that she has very little sympathy for people who have been disenfranchised from the vote, namely people who have prior criminal records. And so that's something to be mindful about, considering the fact that we've had challenges in Florida and other places to restore, in fact, the voting rights of people who have been disenfranchised through felony disenfranchisement. It's worth noting that the populations in Florida actually, through a referendum a few years ago, voted that individuals who had been convicted of felonies should have their voting rights restored. The reason why this is an issue and may become an issue for the Supreme Court is that Republican legislators in Florida have moved forward to say and enact policies that individuals should only be able to vote if in fact they've paid off their fines and fees associated with their incarceration. There are some that say that this is the equivalent of returning to a poll tax. So that's something that's important for us to think about and to be mindful about. On gun rights, the suggestion is, just as Justice Scalia was quite vocal and also quite open about the importance of gun rights, that a Justice Amy Coney Barrett would in fact also would draw on some version of originalism in order to seek to expand gun rights. Now, it's important to note that for those who say that, you know, a strong position on gun rights is rooted in the Constitution or originalism, well, actually, that's not fully the case. The Second Amendment doesn't read in the way in which gun rights advocates or jurists suggest that it actually should. This brings to mind what some say is that those who find themselves to be textualists and originalists find themselves to be that way only for the purpose of being outcome determinative. One example from the Supreme Court this summer is the case of Bostock. Bostock was the case that the Supreme Court held, which furthered LGBTQ rights by stating that individuals who are LGBTQ cannot be discriminated against in employment based on their sexual identity and status. In that particular case, there were several judges on the Supreme Court, several justices who all claimed that their opinions were rooted in textualism and originalism, and they came to different outcomes and conclusions, which leads many people to wonder, well, what really is textualism and originalism when you can have those kinds of outcomes? And isn't this just simply saying that textualism and originalism are whatever individuals say it is to support the conclusions that they reach? It's also important to note that we really hadn't heard this kind of terminology being used in the judicial sphere prior to the nomination of Bork to the Supreme Court. He was a person who used this kind of language. So this isn't even something that goes back to the early 1900s or 1800s or 1700s, but is a kind of modern iteration altogether. With regard to the death penalty, according to the New York Times, in a 1998 writing with John Garvey, now the president of Catholic University of America, Judge Barrett suggested that Catholic judges should recuse themselves in some death penalty cases that might conflict with their religious beliefs. And the New York Times goes further to say that at her 2017 confirmation hearing, she said that she would, in fact, recuse herself were she a judge in a death penalty case. On the Seventh Circuit, though, she has voted to allow executions to proceed. So despite the fact that Judge Barrett has said when she was being nominated to the Seventh Circuit that she would recuse herself, while being on the Seventh Circuit in cases involving the death penalty, she has not actually recused herself, but instead has actually voted to allow executions to proceed. This is also quite different than the jurisprudence that we saw coming from Justice Ruth Bader Ginsburg. On questions of discrimination, there are those who also worry where Judge Amy Coney Barrett will come out. Again, according to the New York Times, in writing for a unanimous 3-judge panel last year, Judge Barrett revived a lawsuit from a student who had been suspended by Purdue University after a school disciplinary program found that he had committed sexual violence. What she wrote was the following, which was that Purdue's process fell short of what even a high school must provide to a student facing days-long suspension. This involved an allegation that the student had been suspended for committing a sexual assault on campus. She wrote a lengthy dissent in June, again, according to the New York Times, that she actually would have overturned a trial court ruling blocking the Trump administration's efforts to tighten the public charge rule, which allows officials to deny permanent legal status, also known as a green card, to immigrants who are likely to need assistance, meaning ultimately that she would have sided with the Trump administration against individuals who were seeking immigration status. She has said that litigation is not the vehicle for resolving policy disputes such as that. So let me conclude with the following, which is that, one, it's important to note that judges may, in fact, judge differently than what we understand them or what we might think that they might do once they're actually on the court. But in this case, Judge Barrett has already been on a lower court, and she's also written quite a bit and has articulated that she's in the vein of Justice Scalia. So this puts the question in a little bit different category, meaning that we're not talking about someone who has just simply been in practice or someone who's been a law professor, but instead we're talking about a person who's already articulated her points of view while on the bench and has already articulated her points of view in writing and has already said that she sees herself as a Justice Scalia kind of judge. All of that considered, then that means that she's going to be conservative leaning. I'd like to make another point too, which is that what does that mean that a judge is conservative leaning? Judges have had ideological differences on the court for decades and centuries. There's nothing different in that. If you think about Roe v. Wade, it's a 7-2 opinion. Of the 7 judges that decriminalized abortion, 5 were Republican. Justice Blackmun, who actually wrote the opinion for the court, was appointed by Nixon. And this is actually a really important point, which is that what we've seen in recent years is actually very different than what we've seen of the court in the past. The court in the past has been concerned about upholding the rule of law and being nonpartisan. The concern about where the court is today is not one about ideology and ideological differences, but instead a court that may seem to see itself as a legislative wing of government, or even worse, a wing of government that is responsive to the president. We saw this concern raised by Justice Sotomayor, a member of the Supreme Court, as she has said that the Supreme Court, or at least the conservatives on the Supreme Court, have given a speed pass to the Trump administration to bring anything before the court that he wants to see changed. And that is deeply disconcerting. And it's also deeply disconcerting that in the process of the last few years, with what some have said has been President Trump stacking or packing the court, what we've seen is that the American Bar Association, which is a nonpartisan organization, has deemed many of those individuals to be non-suitable, non-qualified for their service on the federal bench, And they're not alone. There have been state organizations that have also deemed some of these nominees to be unfit to serve, not just on the federal bench, but also in their home courts, in their home states. These are all issues that should be at the forefront of what people are thinking about, not just simply related to Amy Coney Barrett, but the process altogether as to who sits on our Supreme Court and the legitimacy of the Supreme Court going forward. Let me conclude with the following, which is that in recent times, Justice Roberts has iterated that the Supreme Court and judges, there is no such thing as a Trump court, Trump Supreme Court, or Trump judges, or Obama judges, or Clinton judges, or Bush judges. And you may wonder why, in fact, the Chief Justice of the Supreme Court had to articulate that. I think that part of Chief Justice John Roberts' articulation of this principle was the fact that the Supreme Court and also these federal courts have come under attack by the president and also by members of Congress, giving the impression that if these courts don't side in the way that the president wants, then the courts themselves happen to be illegitimate. Well, the very notion of all of that is illegitimate because our courts are supposed to be independent. And the very reason why judges serve for their lifetime appointment, even though that's actually not in the Constitution, is the idea that they can be on these courts and serve in non-biased ways and not be fettered by the pressure of a political party. But much of that has come to be contested in recent years. And I think for good reason, given the politicization that we've seen of this process. That politicization of the process did not start during the time of the Trump administration, but we saw that during the Obama administration, where President Obama was restricted by the Senate from being able to get judges through the confirmation process. And with that, I'll close and open it up to questions.
Professor Goodwin, we just can't thank you enough for all your knowledge. And we are just also grateful that you are teaching and influencing the future lawyers of America for future generations. Thank you so much for all your expertise. Okay, now we will have some questions, and our second Vice President, Rebecca Gilad, will be posing those questions to you. Thank you.
Thank you, Sue, and thank you, Ms. Bratcher Goodwin. I wish you were my teacher every day in the next 30 years. So let's start with the first question, which is, do you have any hope you can address to us regarding the Democrats, any protection for our healthcare, abortion rights, and issues coming up at a later date before the Supreme Court, where we can have hope for the protections of Americans when Coney Barrett as Justice of the Supreme Court will be dominating?
It's a very good question, and it's a question that speaks to states' rights as well. So we live in what's called a democracy, and a democracy that's based on federalism. And what that federalism means that we have a central government that's located in Washington, D.C., a House of Representatives and a Congress, and that we also have states. And the states also have their local government, a governor that signs legislation that's been enacted or passed by the local state legislatures. It's really important that we keep that in mind, given that there are concerns about what might come through a Supreme Court, and that having laws enacted at the state level could protect individuals' rights, from the environment to reproductive health care and rights to healthcare. Even, when Mitt Romney was governor of Massachusetts, Massachusetts went forward to try to fashion some version of universal health care for the people of Massachusetts. Some of the Affordable Care Act was, in fact, based on that. The state of California has ensconced in its state's constitution a right to privacy and autonomy. And New York has recently taken a kind of page from that book and enacted something similarly, as well as in the state of Illinois. So for states that will seek to protect reproductive health care and rights, they can get to work at that, either amending their state's constitution or just simply passing legislation that provides for certain key protections. And that can be done across a variety of areas, whether it happens to be with environmental protection, protection for children, protection for immigrants, protections for voting. All of those things can take place at the state's level. So that's really important that people understand that, who are coming into political office. I'll give you an example that actually doesn't relate to the kind of issues of our time, but it relates to reproductive health care. In the state of Colorado, in 2018, and we've seen across the country in 2018, after the 2016 election, there were lots of women running for office. And so what does it mean when women run for office and are in office? There may be issues that they hear that their male colleagues who've been in the state legislature simply haven't been paying attention to. And there's a legislator in Colorado, and it came to her attention that women incarcerated in Colorado had to show male guards that they were menstruating. And in order to get a tampon, they had to prove that they were menstruating to these male guards. Well, how in the world do you prove to a male guard that you're menstruating without somehow compromising your own human dignity and autonomy? But this has been going on for a very long time. And what was revealed as they began to investigate this is that there's sometimes women who had to do sexual favors to these guards in order to get a tampon. Well, having women in the legislature, they put a stop to that. No woman should have to do sexual favors or prove to a male that she needs sanitary equipment, that she needs a tampon while she's menstruating. But this is the point about having diversity in legislatures, right? Things that women might pay greater attention to than men might. So one of the ways of addressing all these questions, think about these issues at the state level. And of course, as we all know, people should be exercising their right to vote.
We have so many good questions. The next one is, how is it possible to add more seats to the Supreme Court? And won't each party just keep adding seats when they come to power?
This is a very good question as well. And my dear colleague, Erwin Chemerinsky, who used to be our dean at the University of California, Irvine, and is now at Berkeley, but he and I are still co-authors, and it's so wonderful. We've been writing together for some years now. And he recently wrote an op-ed about this, that there are things that can be done. And one of the things would be potentially to expand the number of seats that happen to be on the Supreme Court. The criticism associated with this is that, wouldn't it be that Republicans could also do the same? There are some that say that what's at stake now is so dire that if there were to be a Democratic, if there were to be Democrats elected, such as Kamala Harris and Joe Biden in November, that this is something that they should think about doing. And the reason for it is because what's at stake coming before the Supreme Court, some of the issues that I shared with you, but there's so many more. The concern is real, though, and the concern is whether that actually resolves what happened to be the underlying concerns. During this administration, President Trump has been able to get confirmed to the federal bench more judges than any other president since George Washington. So when we think about not just the cases that reach the Supreme Court, but also the cases that will reach the lower courts as well, today, even, there are 3 judge panels on federal benches that are all Trump appointed, that are hearing some of the most urgent issues of our time. And some of these are judges that were never deemed to be qualified by the American Bar Association, judges who, when they went through the process, could not say whether they believed that Brown v. Board of Education was good law, could not say that they would follow the precedential value of Roe v. Wade. This is absolutely unheard of. So there are some that say that given the tone and tenor of the partisanship and the lack of qualification of some of these judges, that there should be more judges that are put on these courts. My sense is that it only looks at one slice of these issues, but there's a much deeper and bigger crisis in our democracy in the United States. And we see that carrying out in many different ways across our country.
Another question, what is the legitimacy of the court if 20 of 30 million have already voted when Judge Coney Barrett is going to be put in court?
Well, first, let me say what brilliant questions coming from the people who participate with your organization. They're just great. The legitimacy of our court is at stake and has been at stake for some time. And we saw that with the failure of Merrick Garland to be able to get a hearing at all. That in of itself called into question the legitimacy, certainly, of the Senate process, but that doesn't stand in isolation. What's associated with that and what's implicated in that happens to be the court itself. We saw the legitimacy of the court coming into question with Judge Kavanaugh. And there were even Catholic organizations that said that they had originally supported his confirmation, but had to withdraw their support for that, given his comportment during the process and given the allegations that had emerged and the fact that those allegations had not been fully pursued and with full reports coming to members of the Senate regarding allegations of sexual assault committed by then Judge, well, not as a judge, but prior in his life. And that those kinds of questions with regard to comportment, temperament, et cetera, needed to be heard and needed to be settled out. So when we think about the legitimacy of the court, we have to look back, not just at this time. I think the concerns that some people have is that right now this is a continuing devaluation of the rule of law and the legitimacy of the court, not that it begins with the nomination of Judge Amy Coney Barrett.
Another question. Oh, I wish we could be here for 10 more hours. That's not the question. Is there a way to remove someone like Kavanaugh if he can be proven to have lied while under oath?
So, and again, just let me say what brilliant questions your audience brings forward. There are limited circumstances under which a judge can be removed from the bench, but a judge can be removed from the bench for illegal and unethical conduct. Now, in this particular instance, there's far more evidence that would be needed, and then at that point, there would need to be the process put in place in order to engage in due process for Justice Kavanaugh and for the individuals that would be bringing the allegation forward. Would that process be triggered is really the question. So I say that because, very recently in the era of Me Too, there have been federal judges to step down, not many, and based on accusations associated with sexual misconduct. And there are judges who are no longer on the court because of that. But that's taken a Me Too movement, and there have been very few judges who have actually stepped down from a lifetime appointment. These processes don't take place frequently. Judges are often given a pass. In recent years, there have been those that have said that judges shouldn't be given a pass, that in fact, they should be held to the same standards of other members of the bar, that when there are allegations that are brought against lawyers, practicing lawyers, that can result in being censured. It can result in being disbarred. And there are some that have said there are far more rigorous processes against lawyers than there happen to be of judges, even when they have been alleged to have been engaged in the same kinds of processes. Those criticisms, I think, are right. I think that they are on point. I think that there have been histories of judges remaining on the bench, even though their behavior would have been such that if they were practicing attorneys, they would have been censured or disbarred. So should we do more? We absolutely should do more in these spaces. And when should that start? It should actually start right away. That is independent of Justice Kavanaugh. That's just as a general matter, making sure that our judges are held to the same standards that we would hold lawyers to. Now, specifically in terms of the kinds of conduct that you think of that a judge or a justice would be called out for if it's brought to attention, and if then there is a process put in place to investigate it, would be issues such as bribery, also sexual assault, things along those lines. So yeah, criminal offenses.
One more question. Is it your opinion at all that President Obama and the Democrats couldn't have done anything to prevent McConnell in 2016 from having them have Merrick Garland be a judge?
Well, let's put it this way. President Carter, and this was a very different Congress at the time, but just think about it. In the 1970s, 1980, President Carter in one swoop put 6 women on the federal courts of appeal, right? He did that. I actually think that strategically and beyond strategically, what is only right for our country would have been another nomination of a woman. I think that would have made sense. We don't have a Supreme Court that reflects the population of our country. It doesn't. We have three, we have two, let's see, we have two women on the Supreme Court now that Justice Ginsburg has passed away, Justice Sotomayor and Justice Kagan. That's it, right? And I think that there might have been a very different response to, I think that McConnell would have had to pivot in different kinds of ways to justify why a woman couldn't get her day, her hearing before this Congress. I think that there are women who would have been deeply concerned about that. I think that women would have been demanding a woman needs her hearing and give this woman her hearing now. She's qualified. There's no reason not to do this. And I think a failure of McConnell to move forward with a credible hearing process would have resulted in women getting out in the streets and women protesting. I think we would have seen, rather than a women's march in January, you would have seen women's marches in March, April, May, June, July, all the way up to the election. I think that that's what one would have seen, because there wouldn't have been any kind of legitimate reason to deny a woman her hearing. And on the other hand, Merrick Garland, as wonderfully qualified as he is, and he is extremely qualified, he has an impeccable record, but there are women who have impeccable records too, but there was no one who was going to get out in the streets for another guy being placed on the Supreme Court, and they didn't. So I do think that strategically that could have been, I think that could have been deployed. The second thing is there could have been a recess appointment, but that recess appointment would have come to an end too. And so that wouldn't, for the long haul, have been a solution at all.
Thank you very much. We have time for yet another question. Can the Supreme Court do anything about gerrymandering? That seems to be the major weapon that lets an entrenched anti-democratic GOP control public offices from local to national, as well as our entire federal court system, including the Supreme Court. What is your opinion?
Well, you know, the Supreme Court had for, well, let me put it, let's go back. Gerrymandering and efforts to suppress the vote and to keep people from voting is part of an old playbook. It's part of an old playbook that dates back to the antebellum period of keeping women from voting, of keeping people of color from voting, indigenous people and Black people. For this reason, in 1965, after that bloody march across the Pettus Bridge, President Johnson then signed the Voting Rights Act to protect voting. And as part of that act, there was review, so that whenever there were states that were looking to do things such as gerrymandering, redrawing lines, etc., it was supposed to go before the Justice Department so that the Justice Department could sign off or not sign off, right? This was part of that supervision that was being done. In the Shelby County decision, the Supreme Court struck down a crucial part of the Voting Rights Act. Chief Justice John Roberts and the conservatives articulated that they thought we were, beyond racism in this country, or beyond the kind of racism that would suppress votes through gerrymandering and whatnot. What we see is that that was actually not the case. They were wrong. They may have gone to their opinions in good faith and believing that the United States had arrived at a different kind of a path or point in its history with regard to race. But clearly, we see that our country has not arrived yet with full and equal equality for all people according to race. So the Supreme Court can, in fact, engage on these issues. The Supreme Court very recently has engaged on these questions, and that is to allow southern states where you see most of this kind of gerrymandering and most of this kind of voter suppression to allow it to continue.
Thank you very much. And we're getting close to our last question. Could you please tell us what is your view on limiting the terms for the Supreme Court justices?
Well, that can make a lot of sense, actually. So there are justices who will serve on the court, and some will retire early, and some will help at the lower courts and the federal circuit courts of appeal. But then there are others that won't. And right now, it's a complicated issue. Dean Chemerinsky, as he recently said on my podcast, there are many people who are very upset with him when he suggested during President Obama's terms in office that Justice Ginsburg and Breyer should step down because of their age. And he said he got lots of attacks for that. But on the other side of that, you could have judges who stay a very long period of time on the court. And then, as you see in this case, with Justice Ginsburg's passing, the person who has been nominated in her place is 48 years old and likely to serve for another, possibly, if she is put on the court, 30 to 40 years. That's 2 to 3 generations of lawmaking that could be very harmful if she's a Scalia type judge to the kinds of issues and interests that certain communities have, such as women, such as people of color, such as people who care about the environment, such as people who care about criminal justice. So I think that term limits is something that should be considered.
Following up on that, something that keeps me up at night is thinking, should have Judge Ginsburg, when she got into her late 80s and President Obama was there, should she have resigned?
Well, that's a really, it's a great question. And there are many women who said, no, she shouldn't. She should be given the same opportunities that men do. So let me back up and say that I think that underlying all of this is a crisis, again, of our democracy. A crisis of our democracy where we have to be so concerned about what a judge's age is and when a judge will step down, because we know that the process underneath happens to be illegitimate and that we can't trust it. The fact that we have judges who are coming onto the court who are speaking to partisan kinds of values or won't answer questions being put forward to them by the Senate. It's things like that that I think undermine trust in the system altogether. So on one hand, Justice Ginsburg should have been able to serve out her time on the court and to be able to pass away in her own dignity with the trust that there is a process that is healthy, that is robust, that is trustworthy, that puts the next judge or justice on the Supreme Court. On the other hand, we are in a time where there is a deep crisis of our democracy, where people do call into question the legitimacy of the Supreme Court, call in the legitimacy of the Senate in these processes, and are deeply concerned about the future of our country. And I absolutely understand that all together. And so I balance those two concerns. I'm not giving you an absolutely direct answer because with that, what I fear is that there will be those who will interpret it that it's women who have to be more mindful in these times, and that it's women who have to step down, and that it's not men who should be thinking about their age and the length of time that they serve on our courts. And I really appreciate being with you all today. You all are just great. And I really appreciate these questions that you've put before me. They're really some of the most important questions of our times.
Thank you. Sue?
Yes. Thank you so much for being here with us today, Professor Goodwin. We really appreciate your taking the time from your busy schedule. And perhaps you could just finish up with a minute on what plans you have for the future and what you're hoping to do in your busy career.
Well, my plans, during this time is to make sure that folks are as educated as they possibly can be about our democracy and are as invested as they possibly can be in our democracy. I think it's really important that we come to appreciate that there were so many judicial opinions that came about in the 1950s, 60s, and 70s where Republicans and Democrats were right aligned, where we could see the same issues and say, these are the issues and concerns that matter the most in our country. And we are aligned in seeing the values associated with women's equality, values associated with racial equality, values associated with protecting our environment. I really wish to see that kind of a day where there is a nonpartisanship on just core values in our United States. But I'm also deeply concerned about the rise of, or the kind of repeat turn, turn to white supremacy in our society. The anti-Semitism deeply concerns me. The kind of anti-immigration that is peeking its head out in our country at a time in which we've just learned that there are over 500 parents of over 500 kids who were detained and kept in cages and we can't find their parents, and that there are over 200 children who've been lost, these kids who were kept in cages by the United States. That's not reflective of our values. And so I think that we're in a crisis of values as we talk about a crisis of democracy. So as much as I can possibly do to help us think those issues through, because they are nonpartisan kinds of issues, and we all have to be concerned about the future of our country and how we not only sustain it, but how we create a kind of future where young people can thrive in it. Those are the kinds of issues that concern me these days, Sue. I'll just close with this, which is to say, I have heard from parents and I've heard from researchers that there are young white kids, particularly boys, who are being targeted with messages to lead them to have racist views and sexist views and anti-Semitic views and so much more. And didn't we see that in Kenosha with the young man who shot 3 people and killed 2 of them?
Professor Goodwin, thank you so much for your time, for your research, for your expertise, and for working towards making our world a better place. And thank you to everybody who tuned in today. And thank you to Rebecca for asking the questions, and to Pat Leftwich for being in charge of the Zoom show. Thank you, everybody, and goodbye until the next time we see you with the Democratic Club. Bye.
Bye-bye. Thank you so much.